Hey everybody, it's Uncle Grumpy and welcome to Grumpy Tonight. It's another Sunday episode here with my wonderful co-host and the mother of the day on this Mother's Day, our legal counsel, Julie Ezell. Julie, thank you for being here.
Thank you.
Before we get started, I want to thank all the sponsors. As always, if it wasn't for sponsors, we wouldn't be here. So thank you to the Greens Bakery. As you can see, it's Sunday. I've got my Greens Bakery shirt on. Yesterday was Saturday. I was wearing my Green Country Bud, which is in Tulsa. I was wearing that shirt. And Friday, I had on my Sweet Leaf in Bartlesville shirt. So I'm representing the best I can here. Also, thanks to, of course, Scissortail Law, which is sitting right next to me, and Max's Garage in downtown Muskogee, and Moto here, who's doing the magic on the machine. So thank you to all the sponsors. If it wasn't for them, we wouldn't be here. So now that we are here, let's start by our little mea culpa with Lawrence here, if I'm pronouncing that right. Yesterday, I see you cringe. Yesterday on the show, Lawrence was on last night, for those of you that saw it, and he talked about the federal hemp regulations and about how THC derived from federally legal hemp is actually legal or not regulated. Not a Schedule 1, but a Schedule 5, like the hemp.
Yes.
And we had some disagreement on message, but it was because apparently you were only getting part of the message. We had a little technical difficulty yesterday.
Yeah.
So walk me through that. What's your angle on what happened and what the law is?
Lawrence was absolutely correct in that THC derived from hemp has been removed from Schedule 1 and moved to Schedule 5. I think the only distinction that didn't get made is that THC still has a limit of 0.3%. Now, as you aptly pointed out, in regards to a patient who might test positive for using CBD or hemp, that would trigger a positive test, even though they are abiding by the law. From my standpoint, I see it, more as a lawyer, thinking somebody, who is cultivating or in possession of hemp that exceeds the 0.3%, that is still not legal. So it's
but what he's pointing out is, as you say, if they test positive, the test right now, correct me if I'm wrong, is positive or negative. So if you're using enough federally legal CBD that has 0.03 THC in it, if you're using enough of that or using it long enough to eventually occur a dirty test, as we would call it, or a positive test, then you could lose your job. But normally you would lose your job, but the way he's defining this is you would actually be not breaking the law because you're using something that is not a federally one or not a Schedule 1 drug.
Well, Chris, I am never going to be able to say that you were right and I was wrong. Those words aren't going to come out of my mouth, but I can say that Lawrence is correct and his interpretation was correct. Yeah, absolutely. Especially even if you get a quantitative test, it's still going to show positive and you really haven't violated federal law. Yes.
Okay, so let's walk this to its fullest. Mm-hmm. Let's talk about safety-sensitive jobs. Safety-sensitive jobs, as in 2612, the employer gets to fire you for getting a card, but say you don't have a card or you do and they don't know, and you test positive, mm-hmm. Okay? Is that not now a defense?
It absolutely would be if, if you are testing positive, especially if it's due to CBD usage that, meets that definition, that would absolutely be a defense.
So, as Lawrence said it to me when we spoke earlier on the phone, you get a doctor to write you a recommendation or a prescription or however he wants to do it to use CBD.
Yes, absolutely.
And then you have a receipt mm-hmm. for legally purchased mm-hmm. CBD. Mm-hmm. that has 0.03 or less THC, and you've just covered yourself. You've now created a lawsuit mm-hmm.
From
the standpoint of a what law would that be, with the Disabilities Act, or
yes, you would actually be covered under ADA because we're not talking about a scheduled illegal substance at that point. You'd also have wrongful termination claims and additional claims. You know what I hate about this is that I can just tell you from my experience that somebody's going to have to be the test case on this. This is going to have to happen to somebody, and and they need to have this exact paper trail, but it would be a valid defense. Yes.
So, really? So, I mean, that's pretty earth-shattering. Think about that. Everybody right now, we've got people already losing their job because of 2612, which hasn't even taken effect yet, right?
Yes, it's funny that you say that. In the last 2 weeks, I have had 3 people come to me who have lost their jobs because they popped positive on a test, have their cards, and their employers are already administering the law as if 2612 was in place, and it's not.
So as of right now, the law is 788.
Correct.
And that's it.
Correct.
And they have the legal protections that come in 788.
Absolutely. And until 2612, that portion of 2612 is implemented, and I think as most people know, I have a lawsuit ongoing right now to challenge that and other provisions. That is not the law. Right now, we are not operating under safety sensitive.
Well, that's a pretty big deal. Where do you think this is? I mean, what I would recommend is at this point that people that are in these safety sensitive jobs spend between now and when 2612 takes effect doing everything they can to convince their employers to not terminate, to show them that cannabis card holders are no different than any other card holder. In other words, not the flaunting of it, not the rubbing their noses in it, not in the, I've heard of people holding up the card and saying, I now have my legal protection, you can't stop me. I just think that's
stupid.
It's drawing unnecessary attention. So maybe at least between now and when 2612 takes effect, some of the people in the safety sensitive jobs can change some minds.
Absolutely. And, as we've discussed before, so much regarding cannabis and hemp and CBD, all of that is about education or a lack thereof. There's so much of a stigma. And, as I've told both you and Moto, if you had told me 2 years ago that I would be this heavily involved in the cannabis industry, I would have thought you crazy. Here we are. And, education is key. And, and especially those that are utilizing, CBD, not only is there additional federal protection, but, the point needs to be made and explained that CBD is not mind-altering in the least.
Right.
And so to include this in the safety-sensitive, defies logic, even what they're attempting to accomplish with that portion of 2612.
I see someone commenting on here that this is a right to work state or right to terminate or at will state anyway, so what's it really matter? Well, it does matter, because if it is, as I've sat in this very building and asked floor leader John Eccles, since it is a right to terminate for any reason state, why'd they need to put this stuff in 2612 anyway? Well, if they need to put what they need to put in there, then we need any protections we can in there. So it matters.
It does matter. And yes, we are a right to work state, in that you can terminate anybody for any time, for any reason that is not illegal. The problem is that, people are utilizing medical cannabis for valid medical reasons. And although, cannabis is not legalized at the federal level, it still implies, disability and healthcare issues which are covered under the ADA. You can't invoke the ADA jurisdiction because cannabis is still illegal at the federal level. However, in Oklahoma, we have statutes at the state level that very much mirror the ADA and give those same protections on a state level. And so that additional, language on safety sensitive was also likely written in to try to do away with any defenses that might be had under what I would call the state ADA. And so, what was commented, yes, it's a right to work state. You can terminate anyone at any reason for any at any time, for any reason, for anything that's not illegal. However, a lot of people want to terminate somebody for illegal reasons, and they come up with fake reasons, like,
right.
when really perhaps, maybe they're racist, but instead they are going to terminate someone saying, you didn't come to work on time, or we just don't need your services. It's still illegal if you can prove that there was the true reason was an illegal one.
So this then gives them the protections of us being able to go back and say, well, we can prove that they fired us for getting our medical marijuana card. Therefore, we want this protection. This saves them from that.
Yes.
So what I'm getting out of this part of the conversation is that we might possibly have some legal protections under the ADA Act?
The state ADA Act. So the Americans with Disabilities Act is a federal law. Doesn't apply right now because marijuana, THC is still a Schedule 1 substance, but we have a similar law at the state level.
And now that we're calling it medicine... Now that we're calling it, saying it's a there's a medical reason here in the state, we have to then acknowledge it under the ADA Acts that we have here in the state.
Yes.
Is that right?
Absolutely.
That's big.
It is big.
That's big.
It is big. And, it's another reason of concern for the safety-sensitive legislation that's in 2612 and, why, we are taking appropriate steps against it, because you do not have any other group of people with medical conditions or disabilities that are singled out like those of medical cannabis users.
Yeah. Something else that Lawrence mentioned earlier just before we went on was that he had spoke with Representative Scott Fettgetter, and that he is hoping to put forward a bill next year, and they didn't say this was a secret, so we're going to talk about it, a bill to help define the DUI situations when it comes to cannabis. What they wrestled about in the conversation that they had just a little while ago had to do with how to tell, and it would have to do with more to do with what's actually in your body versus positive or negative test or standard impairment test. What do you think about that? I mean, I love the idea, and I got to tell you, Scott, if you're watching, please reach out to me. I'd love to help you with some of this summer. I'd love to be involved in this. This, I think, is a good thing. What do you think?
I also think it's a good thing. I think, the intent of any of our, DUI laws are to keep people who are mentally impaired or intoxicated off the road. And that is not a lot of people who are using medical cannabis, especially when, they haven't used it immediately prior to driving or aren't using it while they're driving. The goal here is to keep dangerous drivers off the road, and citing somebody who, doesn't have any kind of mental impairment or effects from it, it doesn't get to that goal. It just pushes forward, the stigma against cannabis.
Now, what they talked about would unfortunately have to be a blood test. That I have an issue with. I like the idea that's been tossed around about the cognitive test.
That's what I agree.
That we talked about with the safety-sensitive jobs as well. I think this bleeds right over to that.
Right.
Where all an officer would do is maybe have a tablet on them, and they give you a cognitive test, and you have to. I don't know. I don't know anything about a cognitive. That's not my area. But it just seems to me like there might be another way to do this besides drawing blood, because that, I think, is a violation and starts, then what else are they looking for?
Agreed. And if you think about cannabis and potential impairment like we treat alcohol, when you are pulled over for potential DUI alcohol, the officer is looking for, probable cause, impairment in your driving, and then makes you do the standard field sobriety tests. The same thing, should apply to cannabis, and that shouldn't be pulled over unless there's, something with your driving, probable cause, and then only cited if you're demonstrating impairment, whether that's through a field test, walking the straight line, the alphabet backwards, or something on an iPad to determine impairment. But taking that back to the safety-sensitive positions, you think about somebody who is a regular alcohol user, they come into work and they drank the night before, but they're perfectly fine. They're allowed to work. Yet somebody who is a medical cannabis user who, again, used it the night before, not currently impaired, wouldn't be afforded that same protection.
Not to go down a rabbit hole, but you said something about saying the alphabet backwards. I want to I take exception with that one because being dyslexic, I can't say the alphabet backwards. I'll never be able to say I would have to study it backwards to be able to say it. So I think that needs to be eliminated from the test.
I would like to ask any law enforcement officer that is out there to look out for this guy, pull him over and get the alphabet test.
No, we're not doing the alphabet test. No. Okay, Julie, I know you had a few things you wanted to talk about. Let's hear it. What you got on your mind?
Well, one of them, we recently just talked about was that I have had, multiple people come to me within the last 2 weeks who have been straight up terminated from their jobs for having a positive THC test when they are not in safety sensitive positions and when 2612 has not even gone into effect yet. Keep in mind that 2612 and all of that requirement is not going to go into effect until 90 days after the legislature adjourns. They've not adjourned yet. We can't even begin counting the 90 days yet. And employers seem to be in the mindset that this is already law. And so, I would ask people to stay very aware of that. And, again, the education with your employers, not only on, cannabis and, them understanding the medicinal benefits, but, education on the law in that law is not into effect, and working with their employees and the community on how to fairly and appropriately implement that.
I've noticed an enormous amount of people in the industry aren't sure about the law. I can tell you most days I get up and I have to question at least one or two aspects of it, because you have to look and see what was signed the day before, what he did, what happened last week affects what he signed, the governor, that being he, the day before, and it's getting confusing. It may have been you who commented on it. I saw a post earlier today. Somebody said something about writing a book or a pamphlet to explain to everybody what the law is. I can tell you, and Lawrence and I talked about this a little bit last night, I do want to take the show on the road, and by that I don't mean go to patient drives, okay? I mean, I want to take Julie and perhaps Lawrence and Norma Sapp, if you're out there, I want you to go too. And I want us to go to some of these small communities where we hear some of these horror stories, and we'll rent a room or whatever you have to do to get a room in the public library for a day, or whatever we have to do to set up for 2 or 3 hours, get everybody in that town that we can to gather up and tell them what we know about the law.
Absolutely.
And we can, I think between all of us, we can probably get pretty close to on the mark on just about everything. I mean, Norma herself is, I think, more on timing with the laws than anybody. So, and we could take this to the people. That's what I mean by take it on the road.
A cannabis town hall in the individual community.
Yeah, and I'm betting, and I'll throw this out there to the representatives that may be watching, I'm betting that we can get the representatives in that district to show up and do this with us. I really do. I guarantee you, if we show up in Scott Fettgitter's district, he's going to want to be there.
Yeah.
So I'm betting the rest of them will want the same thing, because we're going to be talking about what we believe the law is, and if we're wrong, maybe they should be there to help correct us.
Yeah.
I think that could be really successful.
I absolutely do too. This is a collaborative effort, between cannabis users and non-cannabis users and the government and employers, and everybody has an interest or a stake in this conversation. I met a Rogers County deputy sheriff. We all know Rogers County. We all know when it comes to bad press on cannabis, I think Rogers County is one of the worst in the state. We all know a particular sheriff there that seems to be the instigator of some of this from our perspective, from outside. Well, I met one of the deputies that worked with him at the Capitol. I think I've told everybody about this once before. And we talked about the incident with that happened with where Chip Paul was forcefully removed from an event for being a disturbance. And I can assure you he was not by any means the loudest disturbance there. He was just a target. And I was there, so I speak from firsthand experience, from seeing it with my own eyes. And I talked to this guy about that, and he agreed that thing just got out of hand, that they wished it never happened. And he actually said they'd be willing to sit with us
if some of us want to come into their community and have a meeting like this with them.
That's great.
So perhaps we could, perhaps some here watching can help me. Perhaps the representatives in that area can help me. And let's make arrangements for us to go down and meet with all the law enforcement in Rogers County and just have a little town hall with them and give our perspective as the cannabis users, as the card holders, our perspective of how we feel in their town, and they can give us their perspective of how they feel trying to be law enforcement in that town. And maybe if we can see things from each other's perspectives a little bit,
right,
maybe we can tone down the rhetoric a little bit, and maybe we can change things. So
I think that's a wonderful idea, and I would, say to anybody out there watching, if, you want to suggest your town or your county for us to come out, if you're, aware of these types of issues or, need for communication, comment, drop one of us a line and let us know. I think it's a wonderful idea, and I'll agree to do it, provided that you cut your beard.
Yeah, okay, well then we'll just have to phone you in, because that's not going to happen. All right, folks, let's take a vote. Who wants to cut the beard? We'll check the count after the show. Okay, after the show. It's not going to happen. It's just not going to happen. Okay, what else would you like to talk about? Hey, I got one for you before you get started.
Okay.
We've been talking about bills, some that have passed recently and have not. And those that know it and those that don't. Okay, SB 162, that was signed last Wednesday. That's the one giving all the doctors with good standings. Let's reaffirm that. What do you know about that one?
So that is the bill that allows any doctor licensed by the State Board of Medical Licensure or the Osteopathic Examiners Board to write medical marijuana recommendations. Under the rules drafted for 788, these doctors, not only did they have to be licensed MDs or DOs, but they also had to have some kind of national board certification. That national board certification requirement has been dropped, and so they just have to be a licensed doctor through their residency in good standing to practice medicine to write these recommendations. And I will also say that that bill was signed by the governor on Wednesday, and there were a number of doctors who on Thursday were ready to write recommendations and ready to get rolling, but the OMMA procedure and form had not been updated at that time. And so luckily it was worked out with OMMA that by Friday, the OMMA had published on their Facebook page a workaround for the time being so that law could be quickly implemented and, patients could get greater access. And so as much at times, negativity as we hear or experience about OMMA and their response, they did a really good job of handling this one in an incredibly timely fashion. That was pretty quick.
They could have put
absolutely.
They could have thrown a problem in there.
Absolutely, and especially for state government, that is incredibly quick and was very refreshing and appreciated.
Yeah, and I want to give a shout out to a particular doctor.
I can't imagine who you're probably going to shout out to.
We all do. Dr. Randy Whitekiller has been in this fight from the beginning. I've seen him at the Capitol more than any doctor I've seen at the Capitol. So for that, I want to give him a big thumbs up. He was day one putting out ads for writing recommendations, and I think that's great. So I'm happy to see it.
Yes, I am too. And I will go a step further and say that I've actually never met Dr. Whitekiller, but I'm Facebook friends with him, and I see that he is doing his recommendations for a maximum price of $60.
Yeah.
Veterans get a substantial discount, and people with other hardships. And I just commend him for his commitment and demonstration that he is truly doing this for the patients and to help patients, not to line his pocketbook whatsoever. Yeah,
if he was trying to line his pocketbooks, he would have walked away from this a long time ago. Like right. I said, he's been there.
Yes,
he's actually been there. So I'm happy to see him get to do what he wants to do. Mm-hmm. I mean, we should all get to do what we want to do. And I'm thrilled to see this happen because, as Lawrence and I talked about last night, I see this as a big drop in the price. I see this as forcing the prices down. Mm-hmm. I don't know how all these new doctors that are going to sign on with this,
Right.
would do it, and the price maintain where it's at now.
Agreed.
So,
and I would additionally say that, most PCPs, a lot of primary care physicians, especially in rural areas, are not board certified. So not
right.
only does this help from a price perspective, but this really is going to get the accessibility to people in rural areas, which is, what we need in this state.
Yeah, there's not enough of that. And, I know there's patient drives. I've been on a bunch of them myself, and most of these doctors that are doing it have done at least a few patient drives in little towns out in the middle of nowhere. And it's because those doctors in those towns that live there have been trying to charge $250 or just refusing to do it. So what I see this doing is this opens the window for, or opens the door for doctors to just do it during a standard visit, and therefore go in on your insurance if you have insurance. Now, I realize a lot of people don't have insurance. Those on disability, some of us are lucky enough to have disability insurance. So like mine, my doctor tried to write mine the first day, but he had the board certified issue, and he wasn't charging me a fee. He was doing it during a standard monthly, check my blood pressure, write my prescriptions, give me all my regular. I have health issues, so I have to go fairly regular. So it wasn't going to cost me any extra. And I can assure you, he was mad. He actually kind of blamed me. He kind of somehow thought I was involved in this, but yeah, there was me and one other person he wrote him for, and they got kicked back, and he went nuts. He could not believe the state would do that. And when I walked into his office for my meeting, my normal meeting where he talked about me, and he's always in a hurry, he started talking about that. And I said, well, I realize you're in a hurry, and I've been out there for an hour and a half already, so let's talk about me. And he said, no, I'm not in a hurry. You're going to listen to me. And he really let me have it because of that. So I'm thrilled to see 162 signed into law.
Yes.
Now, David Van was pointing out last night 162 had some other issues in it. I did not know that. Apparently that slipped by, allowing them 15 business days to get you your license rather than 15 days.
Yes, and there's language altering a lot of the timelines, not only in that bill, but as well as in 2612, and I think it's 2601 that is in Rules Committee right now. 2612 changed business application response timelines from 30 days to 90 days. This is relatively, well, I can't say it's relatively benign, because it does change it from calendar days to business days, and that is for the OMMA to, notify you of acceptance or rejection. And we all know that the rejections come through one by one. So, they send you a rejection saying, oh, your picture wasn't right. You fix your picture, and then they have their full timeline again, then to send you another rejection saying, oh, there was a problem with your recommendation or your address. And so the clock restarts every time. And so this is going to draw the clock out on those. I would personally like to see something that if they're going to reject, tell you every basis.
Yeah, aren't they? Well, once they find the first mistype or whatever, aren't they sending it back then and not even reading the rest of it?
Yes, and so these people are having to do this, send them in rejection process 3 and 4 times with the full 14 days each time before they're getting all the issues corrected and their license approved.
Okay, would we be ready for a break here shortly? Okay, folks, we've been going about a half an hour. We're going to take about 5 minutes to gather our thoughts, and then we're going to come back and finish up. Stay with us. We'll be right back. In the summer of 2018, despite a fierce and well-financed opposition, the state of Oklahoma passed State Question 788, giving the citizens the most open medical marijuana system in the U.S.
The people of Oklahoma spoke last night, and they said they wanted medical marijuana.
Critics tried to frame 788 as being too loosely written, pointing to the bill's lack of qualifying conditions. Proponents countered that the bill would allow maximum access to the widest range of patients. State Question 788 passed by more than 13 points. My friends call me Grumpy. I'm a citizen lobbyist on the front lines of the cannabis revolution in the great state of Oklahoma. I represent not only the 507,000 individuals that voted for medical cannabis, but my fellow citizens who need this medicine. Join us as we travel the state to meet with politicians, activists, business owners, but most importantly, patients. And we are back. Welcome to Grumpy Tonight, Part 2. Is that what you call it? Part 2? Is it Part Deuce? Part Due? With my co-host, Julie Ezell. Once again, I want to thank the sponsors, because as I always say, if it wasn't for sponsors, we wouldn't be doing this. But rather than run down a list of sponsors, I want to talk about why, okay? The sponsors that pick up the show, the sponsors that help me do the show, support everything that we do. And what is it that we do? Well, what I try and do is this, for one thing. I try and give you guys the most up-to-date information. I try and bring you people that you might catch on the news here or there for a minute or two, but I can get them to sit here for an hour or so. So I get us some access that isn't really out there anywhere else. And the sponsors that help do this, they don't ask for anything. And that's what's relevant, and that's what I want to point out about the sponsors. I'm not a private lobbyist for the businesses. We have lobbyists that do that. I'm not a registered lobbyist. I fight for the patients of Oklahoma. I admit I'm selfish. I fight for myself. I am a patient. And that's why I do what I do. And every bit of pull I can muster at the Capitol, that's what I use it for. And the sponsors don't ask me for anything. They never ask for any favors in any way. They just say, keep doing what you're doing, because they know if we take care of the patients will take care of the businesses. So that's why I always say support the businesses that support us, because they're supporting you. So in that note, thank you to the Greens Bakery here in Oklahoma City, Green Country Bud in Tulsa, Sweet Leaf in Bartlesville, Scissortail Law sitting right next to me here in Oklahoma City, and Max's Garage in downtown Muskogee, as well as Moto here at the Bunker. If it wasn't for all the sponsors, we wouldn't be able to do this. So again, support the people that support us. And if you want to sponsor, step up. We're interested. Let's talk. All we ask is that you do everything legally. That's about it. That's it. I don't want to be standing too close to somebody when they get caught doing something wrong. So also, let's remind everybody about the event we've been working on, the Green Retreat. That is June 28th and 29th at Lost Lakes here in Oklahoma City. That's going to be a blast. I'm getting a bunch of lawmakers out there. I'm talking to them quietly about dunk tanks. We have 2 dunk tanks, and I have a feeling that they will be willing. I really do. These people, I think, are better people than we give them credit for. And I think when Representative Fettgetter comes out there and sings some AC/DC, we're going to get a bunch of representatives out there to support him. And when they're out there, we're going to take advantage of that opportunity to get them to interact with you guys. So what I'm thinking is we set up a panel discussion where we line up all these people on the stage with myself and Lawrence and maybe you. I'm hoping you'll be there.
If you're in the dunk tank, I'll be there.
I you know what? I just might do the dunk. If it raises money for charity, I'll do the dunk tank.
I will pay some good money for that.
Okay, well then I'm going to take at least a little bit of time until she runs out of ones. It'll be like a stripper bar. Until she runs out of ones, I'll be in the dunk tank.
Chris, there are children.
Oh, I'm sorry. I'm sorry. Okay, but anyway, like I said, I think this is going to be a great event. We're going to have a bunch of bands. Like I said, we're going to have a lot of representatives out there. I'm really hoping that my friends at the Capitol help us and we can get the governor out there.
Oh, wow.
I would love to see the governor show up. And I think if we have enough of them showing up to this discussion panel, and this has enough eco-friendly businesses involved, that we just might be able to make that happen.
Yeah, and for everybody that's watching, this event that we're working on, the Green Retreat, this is not a one-size-fits-all. This is, open to anybody, whether you're, in the cannabis community, in, just a citizen interested in education, a business, a legislator, anybody is welcome. And there's going to be just a variety of events going on, from music to vendors, nature walks. I think there's going to be a dive-in movie. There's a lake there with,
there's actually 3 bodies of water.
Yeah, water slides. It's just an incredible place, and it's going to be like a festival vibe.
Well, there's 3 bodies of water. I know one of those bodies of water has ramps in it that they pull people around on the water boards by a cable, and they jump the ramps. One of them has the largest water slide in the state of Oklahoma, and that one also has the largest on water
obstacle course.
No, it's an inflatable
trampoline
activity center.
Yes,
basically,
yes.
It's almost like a huge inflatable dock that stretches across the entire this part of the lake. It's really big. So, and we will be swimming. No one's gonna be told to stay out of the water. So,
can you imagine?
Think big.
Can you imagine a 6'3" female in a bathing suit jumping across that thing? Bad idea. Not gonna happen.
Okay, I'm not gonna comment on that one. But there will also be camping out there, and I know Norma Sapp has been waiting to use one of her some new camping gear she got. So she says she's going to camp, but I said, well, I'm don't camp. I'm just too.
You're such a prima donna.
Yeah, I'm just I can't handle camping.
Flower.
Right. I would have to have an RV. So then Norma immediately said, "Oh, well then I'm sleeping in the RV." So we might have to have like a VIP RV.
Yeah.
I don't know. We'll see. I'm just too old to go without indoor plumbing.
Yeah, you are old.
Yes. Yeah, I don't deny it. It's okay.
Is what it is.
It's okay, kids. It's okay. You keep it up. All right, so that's enough of that event. Let's get back to some serious stuff.
Yeah, kind of two other things that I wanted to touch briefly on. I think that we are all fully aware that the bill requiring marijuana waste disposable management was signed by the governor and is going into effect. And as everyone remembers, that requires, commercial license holders to use one of these waste disposal companies to dispose of, certain waste. It does exempt, stems, leaves, stalks, root balls, all of that. But there's just some concern about the law, and the big issue is that it limits the disposal license holding companies to 10 in the first year. And a lot of people have screamed, oh, that's special interest. My understanding is that bill was actually pushed and sponsored by OBN, when OBN was thinking or hoping that a lot of the medical marijuana authority was going to be transferred to them. And I can't speak to where the limit to 10 licenses came. I do think that it seems to be an arbitrary, and it does kind of smell funny. But I've heard a lot of people saying that behind that initial bill was a cannabis lobbyist that many of us are familiar with, and has done some good things for the community, but my understanding is that he was not behind that bill, that this came straight from the OBN.
Okay, well, unfortunately, first let me set this up. I'm frequently accused of lighting the state on fire with some of the things I say, or saying things that are inflammatory or get people riled up for no reason. I personally don't think that's what I do. I think I'm fairly moderate in what I say. Some people tore me up the other day because, well, they didn't tear me up. I don't mean that, and it's not a problem. I want to hear what you guys have to say. But they were upset that I had said something about some dispensaries taking copies of driver's license. I implied that some were selling that information. Now, if I led anybody to believe that all dispensaries were doing that, I apologize for that. And if any dispensaries that aren't doing that got blamed for that, I apologize for that. I spoke only of facts that I knew, as I always do. No, I did not name names because that's not what I'm here to do. I'm not the police. But I do know that these things go on when I say them, but I will be more mindful about how I say them. Mm-hmm. And I set that up before I comment on SB 162, which is the bill you're talking about right now. This is what Lawrence is rightfully titled the Soprano Bill. And that's because I had a meeting earlier today where this was discussed. And I've been waiting to see a contract telling us what these fees are going to be.
Right.
And I've now heard numbers. And
what are those numbers?
I'm very concerned. Yes, I will share. I'm concerned because I'm hearing numbers in the neighborhood of $500 a month.
That's ridiculous.
Per grow.
That's
and
ridiculous.
Now the problem is if you've got a grower who's only producing 4 pounds a month or something like these were the numbers thrown at me. That what they're going to be doing is basically to cover this, they're going to add $1 per gram. They're now trying to say that the cost is going to go up $1 per gram because of this bill. Now, I haven't gotten out my calculator. I just had that meeting an hour before I got here. So this is pretty fresh stuff. But I'm very concerned about that bill. I'm also very concerned about the way it's going to be used and used as an excuse. Mm-hmm. I'm not saying that I expect the dispensaries or the growers or anybody else to make no money. That's not what I'm saying. But my concern is that when they get a 75 cents added to their line, they add $1 to the price.
Right.
And so I haven't done the math yet. And again, this is not to set anything on fire. This is not to cause any issues in the industry. I'm just here being honest with everybody about what I see and what I hear. And I'm trying to keep you guys informed on what I know, the best of what I can without, as I've said, setting the state on fire.
Well, and Chris, my response to that, unsolicited as usual, would be that you are entitled to your own opinions. And like you said, I have always known you to present facts that you were either told to you or you witnessed, and you're entitled to your opinion, and I appreciate the freedom you have to share that. And just because you are saying something doesn't, people need to take their own responsibility, do their own research, and form their own opinions. And that's just the way you best conduct life. And so if somebody's going to get upset with you for having an opinion when you've done your research, then find that to be rather ridiculous.
Well, and look, you say I only report about what I've either seen or what someone's told me. I can tell you if it's something someone's told me, I've made sure.
Right, to verify.
I've used more than one source.
Absolutely.
Because this industry is rampant with rumors. Mm-hmm. Most of them are not true.
Agreed. And you talking about pricing on what these, waste disposal companies might be charging. I find it interesting that pricing is being discussed because none of these licenses have been awarded that we're aware of. And, the OMMA hasn't developed rules implementing this program. So for anybody to assume or imply that they have a license would seem quite premature.
Well, now unfortunately, I think this was all laid out before the bill was passed.
I agree.
And the people I met with this earlier today told me they saw the contracts. They said the same thing you said was, how could that be? We're not even there yet. I want to see some contracts They were then faxed the contracts for a fee of about $250. I think we were $125 a week or $250 a week, something, depending on how much you had. And then it was a minimum up to a maximum, and then it'll increase from there. But anyway, the numbers they came down with was it was going to add $1 per gram, and I just
right. And I think we all know by looking at this bill, just your gut tells you, okay, there's somebody here who has an N and is getting some of these licenses. There's no other basis to limit them to 10, and we don't have any other, marijuana license that has that type of limit. Certainly not with growers or dispensaries, and so it's just, further confirmation of what a lot of us have already known.
So where they got them was, correct me if I'm wrong, they have to do this. And your waste, I guess, will have to be zeroed out with every report at the end of every month. Mm-hmm. So I would assume, because you're reporting the OMA once a month, you're going to have to zero out your waste once a month, which means you're going to have the service at least once a month. And they're giving these growers contracts that don't say, when you have product, here's what we'll charge you. They say you will pay us this price per week or per month, and we'll stop by, and if you got anything, great, up to this much. Right.
And my understanding is that a lot of commercial license holders, growers, processors, and dispensaries can go a very long time without having any waste as defined by that bill.
Okay, so in this bill, does this bill say, this is where it's important, does it say that they must use a waste disposal service, or does it say they must contract with a disposal service?
I don't remember.
Because if it says they must contract with the disposal service, then they're telling them they have to be locked into this contract.
If it says contract, that's an illegal requirement. The government can't require
then
you
what
to
we have
contract.
to do is one of these people with these licenses has to dump this idea of a monthly or weekly fee, and they're going to get all the business because they're going to be more reasonable.
Right. Well, and another thing that I've heard is that these businesses are going to require people to sign a multi-year commitment, 5 or 10 year commitment at these prices, and be locked into this, so that if the market does open up and there are more than 10, they're going to be locked in with this, provider that's charging substantially more than market prices. Yeah,
and I think we know we're going to have less growers next year, not more. We're going to have less people growing more. I think a lot of people who bought licenses in the first year, I think we all know, aren't going to be in business in the second year, unfortunately. So that again is another issue. If they've signed into these contracts for years and then they go belly up.
Right.
It's too late to do anything about it this year. Look, let me say what my objective here is with things like this. We've got a lot of issues with 2612 and other bills that we were not able to get fixed this year, and we were not able to get those fixed because we don't have a lobbyist. We don't have a one who fights for the people. And so if we work, as I've said, if we work to get that done this summer, then next year perhaps we can take care of something like this. Maybe this can be altered a little bit.
Yeah.
All right, what you got there?
The other bill that I would just, invite people to keep their eyes on is House Bill 2610. That one is currently, it has title stricken, and it's in joint committee. And why that is important is typically, when you strike title on a bill and it's in joint committee, those are the bills that you typically see, significant changes being made, because when you've stricken title, it allows you to make a lot more changes to that bill than you normally would be able to. And so, 2610 started in the House, passed over to the Senate. Senate made some amendments, sent it back to the House. House wasn't happy with those, and so they do a joint committee to try to work together and come up with a final product. Well, that final product can literally be anything, but looking at the bill right now, there are very concerning amendments to that bill, such as deleting the provision from 2612 that says that all patient information should be, subject to HIPAA and shall not be stored by the department. It strikes that. It's got the language in there that will allow any doctor to write a letter to revoke somebody's patient license.
Not just the doctor who wrote the recommendation, but any doctor.
Any doctor. So
this was all some of the worst stuff that we saw come out of this session.
Right, and it's hanging in through 2612. There is a provision in there which allows counties to kind of opt out and to allow patients to possess more marijuana than is allowed under 788. I don't see that one.
That's actually to grow more. Yeah, that's a bill, and I tried to put a squash on that. I'll refresh everybody as to why. I don't remember what bill that was. Was that?
I don't remember.
Well, but that was one that allowed counties to increase, which is in 788. Counties can increase the amount you can grow as a personal grow, but they cannot decrease it below the 6 and 6. And it said that they could charge a fee. It said what that fee could go for. And here's where the dilemma was that I see. And this is what I ran through to some of the lawmakers who agreed, and I think put a squash on the bill. What would happen is a county could do something as simple as up at 1 or 2 plants. So suddenly you're allowed 7 and 7 or 8 and 8. But now you're also subject to inspections because they've now given you a special permit. Mm-hmm. Well, that comes with a whole bunch of new regulations, and that county writes those regulations, not the city. So now you've fallen under the restrictions of the county you live in because they've allowed you to increase it, but the state has allowed them to take control by doing that. So then the county has to have people to do those inspections. Well, only 12 people in your county applied for that increase because the rest of them are doing it anyway and they didn't want to bring the attention to themselves. Mm-hmm. Okay? Mm-hmm. So 12 people apply for it. They pay the fee. That doesn't produce enough to justify the hiring of somebody to inspect them.
Yes.
Okay?
Yes.
So now the county is now in debt because of this. They're now in a deficit. They're now spending money for a program instead of making money on the program. So the next year, somebody in that county says, well, why don't we just inspect all home grows and give this person something more to do, a justification for all this money? And they say, well, we can't do that. This is a state law. Oh, well, let's give this to our representative. And the next year, I'm arguing with some guy at the state capitol who's deciding that because we don't have to spend any more money, because we've already hired these inspectors to do the increased houses, let's just start doing home, and we need someone to do enforcement for homes. And I just see it as the elephant's nose under the trunk or in the tent. Yes. I really do. I realize that's a long way to walk it, but we have to.
Yeah.
We have to.
Agreed.
This has been extremely strategic from their point. I've been saying this for a year. It's checkers, not chess, not checkers. Some of the protests and some of the things I saw last summer I thought were checkers moves, and they led us to where we're at now. I said back in the summer, if you were to look at 3468 and 1120, which were a Senate bill and a House bill that were around last year before we voted on 788, and you laid out the language in those, and then you laid out the language that's come at us from the Health Department, from the OBNDD, from every other agency, from the Agriculture Department. It was all in those 2 bills. Mm-hmm. So this has been chess.
Right. They
didn't accidentally divide this bill up to 12 committees,
right,
or 12 agencies that aren't even in the same building and send it all, with the same objective. It was a strategy.
And keep in mind that the same strategy is now starting again for bills for next session as well.
Right.
One thing, I know we're almost out of time. One thing I wanted to say really quickly, jumping back to the medical marijuana waste disposal bill, the bill language says that if a commercial license holder, has any waste, then it can only be disposed of by a medical marijuana waste disposal company. So if you don't have any waste, you're not required to license with one of these companies under my reading.
Okay, so then what we have to do is look into these 10 licenses. Here's what I want to do. I want to look into these 10 licenses. I want to see who holds these 10 licenses. I want to cross that with a few other things like what other licenses do they hold and how did they end up in this position to begin with? And then we can start to answer some questions as to why.
Yes, absolutely. And those would all be open records documents that you're entitled to.
And look, if we have these agencies or these companies that are not requiring a contract, but yet call them when you need their services, hey, maybe one of them can sponsor the show.
Yeah.
Because I could get behind something like that. I understand the need to eliminate diversion, and that's what this bill was all supposed to be about. So if you guys want to do it like that, call me. Let's work together on this. If this is a contract where they have to pay a fee on a monthly basis, whether or not they have waste, because they're always going to produce a little, well, then I've got a real problem with that. And Lawrence's name as the Soprano bill, I think, has come to fruition. What do you think?
I am in complete agreement. It will be very interesting to see how this plays out.
Okay. Well, we've just crossed over an hour, so we're going to wrap it up here fairly quick. Last but not least, let's mention the Green Retreat again. June 28th and 29th, come to the Green Retreat here at Lost Lakes in Oklahoma City. Going to be a great time. Sign up, get a booth. If you have a eco-friendly business, I don't care what it is. Look, the way I presented this to some people is we're going to have a whole lot of people who grow at home and who grow commercially. Every single one of them out there wants off the grid.
Yeah.
So there's your customers right there. So there's more than one reason why this needs to be all-inclusive, eco-friendly. We can all benefit from this. We will get some lawmakers out there. We'll get to interact with them. You guys will see they're no different than the rest of us. They'll get to see that we're no different than they are. And perhaps we get lucky and we get the governor to show up.
Yeah, and that's what I was going to say. Everybody come on out because it's absolutely a great opportunity to educate yourselves and educate lawmakers and other people that are going to be there. This is community. Let's
Right.
be community.
Okay, once again, thank you to the sponsors here in Oklahoma City, the Greens Bakery. In Tulsa, it's all these green names I get mixed up. In Tulsa, Green Country Bud. In Bartlesville, Sweet Leaf, one of my favorite places. I went there the other day. And by the way, they do a great RSO program, so I got to throw that out there.
That.
They're really doing things right out there. They've also got a clinic, $50 recommendations. Been that way for a long time. So I love what they're doing there. And Max's Garage, and of course, Moto here at the bunker.
You forgot one.
And Julie Ezell here.
Scissortail
Law, as always, our legal counsel. Without her, I'd probably be in court.
There's still a chance.
There still is a chance. Yes, there is. Okay, folks, that's it for now. Until next time, stay grumpy. I'll see you on the road.